Good afternoon, everybody. There are still seats in the front if you want to come down. It's nice to see a full audience, a lot of excitement here this afternoon. You're in for a really extraordinary afternoon. I am Professor Michael Scharf, the director of the Frederick K. Cox International Law Center, and this is one of our most exciting events of the year, where we get to have the Cox annual lecture and present our Humanitarian of the Year award, which some have called the Cleveland's version of the Nobel Peace Prize. To introduce our speaker and to present the award, it is my privilege to reintroduce you to the Dean of this law school, Gary Simpson. Gary Simpson came to us from being the Associate Dean of Cornell Law School. Before that, he taught at Texas, and he's a graduate of Yale. His fame is in the area of conflicts of law, which is private international law. So he's a real supporter of our International Law Center, and it's been great to have him as a partner in our major activities, including today. So please join me in welcoming Dean Simpson.
Thank you for coming. We're here to welcome Luis Moreno-Ocampo, who's the prosecutor of the International Criminal Court in The Hague. This is the 2007 Cox International Law Center Lecture in Global Legal Reform, and I will present him also with the 2007 Cox Humanitarian Award for Advancing Global Justice. This award was established in 2004. The past recipients last year, you may recall, International Court of Justice Judge Thomas Bergenthal. Prior to that, the International Criminal Court President and Chief Judge Philippe Kirsch, the UN Undersecretary General for Legal Affairs Hans Corell. Mr. Moreno-Ocampo is a native of Argentina. He's been a prosecutor, a trial attorney, a university professor, has been involved in many important cases, including a 1984 investigation that ultimately led to a trial, conviction, and sentencing for 5 senior Argentine Army commanders who included 3 former heads of state. In 2003, the Assembly of States Parties elected Mr. Moreno-Ocampo to be the first prosecutor of the International Criminal Court. He developed the International Criminal Court's prosecution strategy. He has hired the entire staff, which numbers several hundred. He helped convince the United States to end its opposition to the criminal court and to allow the Security Council to refer the Darfur situation to the court. He's brought indictments involving situations in Darfur, the Congo, and Uganda. The law school's War Crimes Research Office, as some of you may be aware, has been providing research memos to this court as well as 5 other international war crimes tribunals. We have sent interns, in fact have some at the International Criminal Court now. Professor Scharf will actually be spending his sabbatical next year at the International Criminal Court. So I want to introduce to you Luis Moreno-Ocampo, and first to present to him the 2007 Cox Humanitarian Award.
Dean, thank you very much for your kind words. Ladies and gentlemen, I would like to thank Case Law School and the Cox International Law Center for presenting me with this International Humanitarian Award. As you say, 2 years ago, you offered this tribute to the President of the Court, Philippe Kirsch. I see this award as the continuing acknowledgement of the significance of the Rome Statute and of the achievement of the International Criminal Court. I see this as an award to all my staff, and to all of those in the court who have helped us build this institution. I would like to continue with you the dialogue about the significance of the Rome Treaty that you started with the President of the Court. As you know, the Rome Statute is an innovative legal design, a 21st century institution modeled to address the threats and challenges of the 21st century. As the prosecutor, I have to apply this new and innovative law. I make daily decisions on new operational standards, and that's why I need a continuous dialogue with academic communities. Today is a great opportunity to enhance our mutual understanding. I would like to explore with you the wide prospects opened by the Rome Treaty. The interaction between the court, states, and international organizations. The goal of the Rome Treaty is to end the impunity for the most serious crimes of concern, including genocide, crimes against humanity, and war crimes, and to contribute to the prevention of such crimes. To achieve its goal, the Rome Statute created an innovative system of interaction of states, international organizations, and a permanent international criminal court, supported by an emerging global civil society. States remain responsible to prosecute the cases in their own jurisdictions, but they have to support the court when the court decides to act, and the court decides to act when there are not genuine proceedings in the national state. So, the court is not the Supreme Court of the world, it's a backup system to enforce, but at the same time, the court is a critical node of this network. States did not only commit to apply the law within their own borders. As I say, they accepted to be part of a novel system of international cooperation. They committed to support a permanent international criminal court whenever and wherever the court decides to intervene. In this sense, the Rome system is more than a court. It created a global criminal justice system. It took more than a century to develop this model. In 1873, Louis Gabriel Monnier, a Swiss lawyer who co-founded the International Committee of the Red Cross, proposed the creation of a permanent and impartial international criminal court. He had a clear view of the problem in those days. He noted that a treaty was not a law imposed by a superior authority on its subordinate, but only a contract whose signatories cannot decree penalties against themselves since there will not be no one to implement them. The only reasonable guarantee, say Monnier, should be in the creation of an international jurisdiction with the necessary power to compel obedience. The world was not ready to that in the 19th century. In fact, the world will witness the horror of 3 genocides. First, the Holocaust, then in the former Yugoslavia, and then in Rwanda, before the international community decided to create ad hoc international tribunals to address these situations. But after, the wars already happened. In 1998, finally, countries from all the continents actively participated in the elaboration of a new and comprehensive body of law, the Rome Statute. Substantial law has been codified in one detailed text, and different legal and procedural traditions have been integrated into a new international model. The duties of the states, the complementarity system, and the conditions to trigger the jurisdiction of the court have been well defined. A global criminal justice system has been established. After 4 years of operation, it is time to take a look at the new system from a wider point of view. My office opened investigations in 4 situations. We collected evidence against those most responsible of massive crimes. The judges issued 8 arrest warrants. Our first trial is about to begin. So the court has made the law a working system and is driving the other actors to new and demanding challenges. I would like to focus your attention today on this interaction. Since the court is in operation, the number of states parties has kept growing. We moved from the 60 state parties required to enter into force into 105 state parties, being Japan the last one. States from different regions. Let me put this down. Yeah. States from different regions evaluated the treaty and its implementation and decided to ratify it. The number of ratifications of the Rome Treaty helped, was not me, to harmonize the work of the court with the UN and other international organizations, as the African Union, the European Union, and the Organization of American States and the Arab League. The UN Security Council Resolution 1583 that the Dean mentioned, referring the Darfur case to the court, is part of this interaction and confirmed this recognition, more remarkable because the recognition included the decision of non-state parties. Today there are more than 40 states that have now passed some form of legislation implementing the International Criminal Court rules and bringing their domestic laws into conformity with their international obligations. Implementing legislation strengthens the interaction between states and the court and also contribute to ending the culture of impunity by condemning these crimes with a louder and more unified voice. For instance, in Colombia, legislation and proceedings against paramilitary were influenced by the Rome Statute provisions. Let me mention one of the most interesting achievements of the Rome Statute is that armies around the world are adjusting the regulations to avoid the possibility of committing acts falling under ICC jurisdiction. This is interesting, starting with the Yugoslavia Tribunal. As you know, one of the most important cases in the Yugoslavia Tribunal is the case they never did, is the NATO bombing of Kosovo. But just the possibility that the Yugoslavia Tribunal open investigation against NATO transformed the rules of the army. They are adjusting. And that's why I'm insisting on the need to see not just the court as an element to punish people, also how the court helps to establish the law. There are national prosecutions of genocide, crimes against humanity and war crimes, and other crimes connected with these atrocities all over the world. Political leaders and negotiators in the context of international conflicts are learning to manage international conflicts and to demobilize violent groups, respecting the new framework established by the Rome Statute. There are continuous discussions about how to execute the arrest warrants of individuals protected by their own government or by their own armies. An emerging global civil society, especially NGOs from different regions of the world under the auspices of the Coalition for the International Criminal Court, has been deeply involved in these activities. So the court's operations are starting to create a new global dynamic. I believe the involvement of academic communities will be invaluable in the analysis of this new system, particularly in introducing new theoretical frameworks to explain jurisdictions that reach beyond any national or regional boundary, and to define how the Rome Statutes integrate sovereign states and an international criminal court in one global legal system. This is a huge challenge for criminal law scholars and professors. Normally, legal scholars focus in substantial law and court proceedings. The first presence of the defendant before the court is the first moment of the analysis. For me, as a prosecutor of the International Criminal Court, when the prisoner arrives to the court room, a lot, I would say almost everything, has been done. It means that my office took the necessary step to analyze crime patterns and to select a situation in the world that require our investigations. It means that we received referral from states or the Security Council or an authorization of the Territorial Chamber. It means that we managed to conduct investigations of massive crimes during ongoing conflicts, to interact with victims and local communities, to protect witnesses and investigators. It means that we secure the cooperation needed to carry out investigation, from visas for our witnesses to the evacuation of threatened staff in deteriorating security situations, to collect the evidence necessary to prosecute those who bear the greater responsibility of the most serious crimes, and to ensure the appearance of the person sought by the court. We have to do all this before we start. This interaction between the activity of the office and external actors make a trial possible, and is not widely known and understood. Just one example. We were interviewing people in Chad, in the refugee camps, but the area became more unstable. So we decided, instead to send our investigators to the field, to the camps, we'll move the witness to a safe place, a city called Abeche. So it was a complicated operation because you cannot move the witness together. So it had to be individual trips to each witness in impossible roads or with a helicopter. So we worked on this for 3 weeks. Finally, we had the witness waiting for our investigators. We sent the investigator to a safe city. The next day, the safe city was taken by the rebels. And they promised not to attack international workers. But my investigators they could think that we were investigating them. So we had to evacuate my investigators in 3 hours. And I need, of course, some state who helped us with a helicopter and planes to leave the place. So it's just one normal day in our life. That's why when the prisoner arrives to the court, for us, okay, it's normal work, but it's normal work, it's not the other. So that's something the scholar had to understand and explain and discuss. Scholars have also to explain the law established by the Rome Statute is not just for alleged criminals, judges, the prosecutor, or the defense. The Rome Statute applies and constrains also political leaders working to seek solutions to international conflict, military actors, diplomats, negotiators, and educators. Your research could help them to implement the new legal framework consolidated by the Rome Statute. We need to educate global citizens. We need to educate global professionals. That's why I'm very glad in this global center. Ladies and gentlemen, among the characteristics that make the International Criminal Court such a novel project, I would like to highlight in particular what the law says they call the proprio motu power of the prosecutor to select situations to investigate. The Article 15 of the Rome Statute defines the judicial mandate of the court and that the legal framework defined by the Rome Statute has to be respected in any resolution of conflict. Few commentators of the statute have measured the impact of this provision. It is the most distinctive feature of the ICC as compared to the previous ad hoc international tribunals. From Nuremberg to the ad hoc tribunals for Yugoslavia and Rwanda, situations were selected by political authorities. International prosecutor could only select cases within the situations. They have no authority to decide not to investigate the situation at all. They could not decide to investigate further than the jurisdiction granted by a political body. Rwanda, for instance, they can investigate in Rwanda during 1994. That's it. No before, not after. The proprio motu power for the prosecutor was the object of strong debate in Rome. Some delegations emphasized that the prosecutor should be empowered to initiate investigations ex officio. Others feared that such an independent power could lead to frivolous and politicized persecutions and would therefore undermine its credibility. The United States, for instance, opposed such an independent prosecutor in the following term: we cannot accept the proposition that an independent prosecutor, unconstrained by any other entity, would at all times act in a political void with no political or personal agenda when initiating a case before the court. Here is a problem between different legal traditions, because, you know, in U.S., the prosecutor is a member of the executive power. In Europe, in most of Latin America, in the civil law countries, normally the prosecutor are a member of the judiciary or are independent. So here the idea is Ken Starr was independent prosecutor. This is normally in the civil law countries. That's why maybe this different legal tradition had an influence on this discussion. In any case, following an Argentinian-German proposal, one idea was generally supported, and it obliged the prosecutor to submit to the pretrial chamber a request for authorization of an investigation before proceeding with a proprio motu investigation. So, in the court, if I decide independently to select a case, I require an authorization from the pretrial chamber. Important is by establishing the proprio motu powers of the prosecutor to open an investigation subject only to judicial review and without any additional trigger from states or the Security Council, the treaty ensures that the requirements of justice can prevail over any political decision. The law is imposed. The interaction with the states are now constrained by law in the international area. This is the first and most important strength of Article 15. States or the Security Council can choose to refer situations to the court, but if they don't, the court always has the possibility to select situations independently through the provision of Article 15 of the statute. The selection of situations to investigate is now a judicial decision. Why is it such a defining provision? For centuries, for thousands of years, conflicts were solved through negotiations without legal constraints or wars. When the world was confronted with massive atrocities, there were essentially only two options available: either negotiate the impunity with the war's perpetrators or go to war. Idi Amin Dada or Baby Doc Duvalier were pushed away into golden exile, leaving the country problems unresolved. In Uganda and Haiti, impunity reproduced recurring violence. In Rome, in 1998, a new and entirely different approach was adopted. The law will guarantee lasting peace. impunity for the worst perpetrator is not longer an option. The treaty creates a judicial actor on the international scene, and the mere existence of this independent judicial actor will provide incentives to the states parties to apply the law. If they don't apply the law, the court will do it. It is a new design, a new concept in the international arena. The law has to be respected. Ladies and gentlemen, the drafters of the Rome Statute were not naive idealists. They were working to create a new institution to address the problems of the new real world. They built the law upon the lessons of a 20th century of massive violence and atrocities, when massive crimes were committed, crossing national borders, and the international community failed to protect Armenians, Jewish, Russians, Tutsis, Arabs, members of different communities in Europe, in Africa, in Asia, in the Americas. So the Rome drafters were realists. They built the law on the recognition that in the 21st century world, the conflicts are different than in the past. Crimes are different than in the past, and legitimacy is a key factor to solve these problems. One example. There are reports connecting militias in Ituri, the Democratic Republic of Congo, with arms dealers from Ukraine and diamond dealers from Belgium, and they are using international banks. This type of global criminality faces national law enforcement agencies. This is a real example. I went to Europol to discuss with the Europol director what they knew about the Ukrainian mafia providing weapons in Ituri. And he told me, we know a lot about the Ukrainian mafia. They are very active in Europe, but we have no idea they were active in Africa because we are Europol. So it's an unfair battle between global criminality and national or eventually these regional organizations. That's why the ICC as a design is so interesting. And in fact, no state, no national state has sufficient power or legitimacy to guarantee the life and freedom of its own citizens if the international community globally is not upholding the rule of law. To protect each of your citizens, we have to learn to protect each citizen in the world. That's the concept we are establishing. Ladies and gentlemen, based on Article 15, my office has the duty to proactively collect information about alleged crimes falling under the court jurisdictions and to select situations to investigate independently. To face this responsibility, we set up an entire divisions. They assess all communication received on alleged crimes falling under the court jurisdictions. In the last year, we analyzed a number of situations. Of those, 4 were selected to investigate and 2 were dismissed: Venezuela and alleged crimes committed by nationals of state parties in Iraq. In 2003, we selected the situations in the Democratic Republic of Congo and northern Uganda. We selected because they were the gravest situations under the treaty jurisdiction of the court. The Darfur case and the Central African Republic case situations also clearly met the gravity standard defined by the Rome Statute. We reviewed the admissibility of the situations and triggered the jurisdiction of the court in accordance with the peculiarities of each case. Let me be clear on this. When we select a situation to investigate, the issue is never whether we will open or not an investigation. The question is how we will trigger it. In the case of the DRC, for instance, in a report to the associated parties in September 2003, I publicly informed that I was ready to use my proprio motu powers to initiate an investigation in the Congo, but I publicly invited its government to proceed with a referral. Let me emphasize again, because of the very existence of the Article 15, the question is not whether we will open an investigation, but how it will be triggered. Ladies and gentlemen, we presented our standards, we made decisions. The fears of frivolous prosecutions were dissipated in few years. As the court is fully operational, states are now confronted with a new challenge. They have to enforce judicial decisions. As of today, 6 of the 8 arrest warrants are pending. States have to enforce judicial decisions that do not necessarily fit with their political wishes. As the court became operational, we, a judicial actor, are actively putting limits to the political actors. This is normal in national system and has to be normal in the international arena. That is the meaning and the strength of Article 15. For the first time, the law is a constraint to the mediators and negotiators in the context of violent conflicts, to African departments and to multilateral departments within the Ministries of Foreign Affairs. Interesting, some of them, instead of making use of the information provided by the judicial investigations, instead of increasing the respect of the law, complain that we have taken away from them their main tools, amnesties, immunities, exiles. They are ignoring the facts, they are ignoring the law, and they are losing opportunities. The Darfur case shows the need to update and harmonize all conflict management strategies with a 21st century solution, respecting the fact and the law, building upon the legitimacy of an independent court to achieve legitimate solutions. Let me use a case to show the problem. In the Darfur case, our evidence showed that Ahmed Haroun, as the Minister of State for the Interior of the Sudan, implemented the idea to use militia Janjaweed with the Sudanese armed forces to attack the civilian population in Darfur. Under his coordination, they slaughtered thousands of people, and more than 2.5 million Darfuris have been forced out of their homes and now live in camps. They were forced to leave their land, their homes, their cattle. Their villages were burned down. Without humanitarian aid, they will die. The judges of the International Criminal Court issued an arrest warrant against Ahmed Haroun and Ali Kushib, one of the militia Janjaweed leader, under his coordination, for 51 counts of crimes against humanity and war crimes on the 27th of April 2007. An Interpol red notice had been disseminated worldwide, so as soon as the indicted individuals travel outside the Sudan, they will be arrested. The government of the Sudan has the legal obligation to arrest Haroun and Kushib and surrender them to the court, but they are refusing to do so. They are denying Ahmed Haroun crimes. In June 2007, when I last briefed the Security Council, I urged the international community to call upon the government of the Sudan to arrest Ahmed Haroun and Ali Kushib. At that time, right after the arrest warrants were issued, there was some pressure on the government. At that time, there were discussions in Khartoum on the possibility to surrender Haroun. But the issue of the arrest warrant have been put off the agenda of the international community. Justice was not formally on the agenda of the Security Council trip to Khartoum in June. The term of reference called the Sudanese government to cooperate on humanitarian aid, security, and economic reforms. No justice. Justice was not mentioned in the UN Secretary General's subsequent reports on Darfur, where the UN Secretariat developed a three-pronged approach. There were an humanitarian, political, and security components only, not justice. There are reports that the humanitarian situation in the camps is worsening. There are bureaucratic impediments to the delivery of international aid. This is systematic. Those who dare mention publicly are expelled from the camp. Malnutrition rates in the camps are higher than ever. There are attacks against international aid workers and peacekeepers. There are raids against the camps and threats to those identified as local leaders. When the women leave the camp, they are raped. The men are killed. The Sudanese Minister of Humanitarian Affairs is supposed to protect the camps and facilitate the delivery of aid. He does not, he will not, because since 2005, the Minister of State for Humanitarian Affairs is Ahmed Haroun, the same man who, as Minister of State for the Interior, attacked civilians and forced people out of their homes and into the camps, is today in charge of the camps and controlling the fate of his victims. Haroun is deciding how much food reaches the camp, who can go there and who cannot. Is this a mistake? Or is this the second phase of his criminal activities happening right now before of our eyes? In Darfur, as in all the core situation, a comprehensive solution is needed. But world leaders, negotiators have to understand that if the justice component of the comprehensive solution is ignored, crimes will continue. In Darfur today, there can be no political solution, no security solution, no humanitarian solution, as long as Ahmed Haroun remains free in the Sudan. Haroun is such a good example of the need to end impunity in order to create lasting peace. In the 1990s, he was active in southern Sudan. He was mobilizing local tribes and integrating them into the Popular Defense Force. He was allegedly called the Butcher of the Nuba. But there was a peace process agreement there, and then he was forgotten. Then he started again in 2003, 2002, 2004. And he's continuing to commit crimes now. It is time to stop Haroun. Arresting Haroun will break the system, will change the behaviors. It's time to do justice in Darfur. The Darfur case connected for the first time the UN Security Council and the International Criminal Court. We are testing a new model to control violence. It is a test for the world commitment to use the law to prevent atrocities. The UN Secretary General Ban Ki-moon said yesterday that justice is a condition of peace, and peace and justice are indivisible. He undertook to continue working with the Sudanese government to promote cooperation with the International Criminal Court. In any case, the request to arrest Haroun will not go away. On December 5, I will inform officially to the UN Security Council that the Sudan is not cooperating with the court. The international community has to maintain a consistent approach and include the enforcement of the arrest warrant in any solution in Darfur. The academic community could help analyzing the problems and designing new solutions. Let me conclude. The enforcement, the execution of the court decisions is the biggest challenge for the international community. State parties of the Rome Statute have to fulfill their commitment. In the words of the preamble, they have to guarantee lasting respect for and the enforcement of international justice. Many actors have to adjust. It will take time. The academic community could help. The law will prevail. Remember how difficult it was for national systems to develop automatic compliance with judicial decisions. We can learn from what happened in this country almost 2 centuries ago. As if you remember, it was a case in which the U.S. Supreme Court ruled against Georgia, the state of Georgia, in a conflict about Cherokee lands. Georgia ignored the judicial decision. After President Jackson reportedly said, "The Supreme Court has made its decision. Now let the Supreme Court enforce it." Things change. It's not possible today. So, and I believe we are witnessing the beginning of a new legal era. We are building a global criminal justice system to end impunity for atrocities and to prevent them. As the prosecutor, my duty is to apply the law without political considerations, and I will not adjust to political considerations. The political actors have to adjust to the law, not the court. The court have no police and not army. We have legitimacy. We will prevail. Thank you very much.
We have the prosecutor has been kind enough to reserve 15 minutes for your questions and answers. So I'm sure that a lot of the students and as well as some of our other distinguished guests today have interesting questions based on some of the thought-provoking remarks you made today. And I'm interested to start off. So I'll let you just indicate who you want to answer the question. The microphone will come. Identify who you are, ask your question briefly, and we'll move through.
You've worked on both national prosecution staffs, and you're now head of a big international prosecution staff. Do you want to comment on the difference? I was at Nuremberg, and we had international there, but you've had an accumulation of experience with national prosecution staffs. Do you have any comments that you want to add based on your own experience in working with these two approaches?
Yeah, okay. Thank you for your question, and thank you for your work in Nuremberg. We really appreciate your leadership. I would say, okay, I was national prosecutor in corruption cases, different than investigate massive crimes. But also there's a difference between investigation of massive crimes in the national system and the international one. For instance, one example, I would say there are not so many differences in court. In court, okay, there are some difference in the different countries, but at the end, we had a prosecutor who had to prove the case, we had the lawyer who had to defend the defendant, and we had to present evidence. So it's basically, in this basic idea, it's almost the same. The issue is before, how to investigate the cases. And in Argentina, I learned how to investigate massive crimes, which is complicated because you have to connect, especially if you like to connect the top leaders, how you connect the more responsible with individual crimes. It's complicated. Even how to select people. When you have massive crime, you have massive number of criminals. I remember I was very worried about this, because I was looking for a legal criterion to define how to select people. And after Nuremberg, there's all them are criminals. Due obedience is not an excuse. So it was no excuse. I remember I met one of your colleagues in '86 in New York, asking him, okay, how you select in Nuremberg? Oh, we had 22 in each case. Why 22? For me, it was an important question because I was looking for my rule. He said, we had 22 because we had a courtroom with 22 chairs. So we select 22.
Who that was?
You know. So basically, this is the problem. We have massive crimes, and it's different with the normal crimes. Normal crimes are for few persons who die. When you kill 20,000 or millions, it's more complicated. In addition to this, that I had experience in my country, was different investigating massive crime during ongoing conflicts. Because in Uganda and Congo, the conflict is today. So I had to learn how to move, as I explained with this story of Chad, we had to learn how to move witnesses without exposing them, because my duty to protect them. I had to learn how to protect my investigators, how to check who is the owner of the hotel. So it was very difficult. That's why we emphasize the need to be very selective in the collection of evidence. Darfur was an additional problem, because in Darfur we cannot protect witnesses in Darfur. So we decided to investigate Darfur without going to Darfur, with the first international investigations without visiting the crime scene. But in this sense it's an advantage, because we screened 600 witnesses in different parts of the world. We finally took 100 statements in more than 17 countries. So for us, going to the country is normal. When I was a national prosecutor, I remember one day I went to Germany, it was a big deal. For us, traveling around the world to collect evidence is a normal work we are doing, and this is a comparative advantage. But probably the most important difference is it is problem of enforcement of decisions. I was prosecutor in Buenos Aires, and now I'm prosecutor of the world. In Buenos Aires was just one city, but I have like 30,000 policemen who will follow my instructions, because I don't need to discuss with the president or the mayor of the city. The rules were there, and Argentina is not a legal paradise, but normally they follow instructions. That's the problem today for me. So the biggest challenge is how the decisions of the court are executed. That's why for legal scholars, like go to Jackson time. Here also you have the same problem. So some areas were refusing, but today, no, it's different. And that's why I think we are at the beginning of a new era in which these global institutions will impose their legitimacy. And this will help a lot to reduce violence, because at the end, the way to solve conflict is not being the most powerful, it's legitimacy. Yes. You, yeah. Yeah, yeah.
I have a very naive question, which is, after President Bush time is over, could he be brought in front of the International Criminal Court because of Iraq?
No, Iraq is not a third party, and U.S. is not a third party. So I have no jurisdiction to open cases against some person from these two countries. The only possibility is a Security Council referral. If not, I have no jurisdiction to investigate any crime. Okay, there are many.
My name is Sarah. My name is Sarah Kostic. I'm a first-year law student, and I'm wondering if you can speak to post-ratification of the Rome statutes, how your investigations have changed for those issues or those conflicts that you began investigating before. What kind of adjustments has your court has to have made in consideration of the Rome ratification?
No, I don't understand your question. Compare with the national prosecutions?
Yeah. In terms of those conflicts that investigation began, collection began previous to the Rome statute being...
No, we cannot investigate nothing. We can investigate nothing before July 1st, 2002. So there's no previous investigations. So Yugoslavia and Rwanda, other tribunals did, but we have different limits. Territorial jurisdiction, crime jurisdiction is 3, genocide, crimes, and war crimes, and then temporal jurisdictions is after July 1st, 2002. So these are our limits. So we did nothing before July 1st.
I understand. I guess my question is more those conflicts that began before.
No, I can. Uganda, for instance, not Uganda. They were committing crime for the last 20 years, and we investigate just after 2002. No, we have to respect the law. Can you raise the hand because?
I'm Carol Fox. I'm an adjunct professor here. I'm interested in your alluding to the time of Jackson as a time when the U.S. Supreme Court could declare things, but they had no way of enforcing them, and comparing that to your situation now. And I wonder if you have an idea of the length of time before the ICC would arrive at the point where you compare the United States justice system being to now, where nobody would, we assume, we like to think, nobody would consider ignoring a Supreme Court decision.
In fact, no, that's why I need academic communities. I don't know. But what I see is, when in Rome, and Michael could say, because he was there, I was not in Rome, so he can explain more than me, but in Rome, people say, okay, this treaty will never be ratified. And in just for a few years, the treaty was ratified. So it was 4 years after the treaty was ratified. And I remember the day of my screening, I was discussing with my advisor in international relations. I said, look, it would be great to work to have a referral from the Security Council, because this will put together justice and security. And she said, you have no idea. You have a 9-year tenure. You will not see one referral in 9 years. So she was right, I was wrong. However, 2 years later, the Security Council gave us a referral. What I see, and that's why for me it's so fascinating work, is things are changing so fast. That's why I'm insisting in the academic community, because my feeling is people is ready. And we legal scholars are not ready still discussing national systems. And of course, national systems are important, but then we need something for the global system. And that's why this court is so unique. So, I don't know, I suppose, look, in fact, I was in the Security Council in June, and no voice was against the requirement. And they are not yet implemented, but no one was against. So now, in terms of principles, everyone agree. But this is like a stop to smoke. Don't smoke is a good idea, but let me start next week. You know, so, but I think we are close. Yes.
Senor, thank you for your comments today and for your contribution that forms the basis of the award. Also, after watching the game with you last night, with the result that we had in it,
and I invited me to stay all to the end of the series.
Fly out to Boston, I think. That being said, on a serious note, you mentioned in your comments that when your prosecutors bring the case in its trial time, that it's done, the work is done. Unfortunately, there is strong criticism in policy circles and in academia from Bill Shabas and others that the ICC is the slowest court in history, and I just asked how you would respond to that criticism. Is justice delayed, justice denied in the context of the ICC? Thank you.
Thank you. No, it's interesting because normally I cannot, we need academia will criticize, okay. My only observation is what are the parameters to measure? So for me, we can be measured from we decide to open investigation, when we present the case, or when the judge issues a warrant. If this is the case, so we start the investigation in Uganda, for instance, in July 2004. We present our case before the judges, against the top leaders, in April, and in June, in July, the judges issued a warrant. So in 1 year, the cycle was completed. When they were arrested, it's something not in my hands. So that's why I believe to measure, we have to understand the system. I cannot be measured because now happened 2 years pass and nothing, they are not arrested, but I can do nothing. The other issue is, it's complicated to measure this court because this court is a complementary court. So suppose this court never do the case, but it's in accordance with the law. So what happened? This court, with no cases, and it's okay. So for me, the issue is we have to review the parameters, how we are measuring. Because in fact, I believe we are the fastest court, we're the fastest court in international court in terms of investigating this type of crimes. So, but we have to discuss the parameters correctly. I cannot be measured since July 1st, 2002 because the court was not existing. I arrived in June 2003, but we had no cases yet. So I think the proper way to measure is, since we open the investigation and we present the case before the judges. That's my way to present the idea, but I think it's important to discuss these issues. Yes?
Thank you for your services. You discussed earlier the outstanding arrest warrant against Haroum in Darfur. You mentioned crime against humanity and war crimes.
Yes.
I was surprised that you did not spoke to genocide. So is it the official position of the Prosecutor's Office of the ICC that no genocide is occurring in Darfur? Thank you.
No, we never did a negative decision. We did a positive decision. We have evidence, and we are sure we have enough evidence to present crime against humanity. Genocide is complicated there, because to affirm a genocide crime, I had to have all the elements to prove all the elements, and that's why we are still collecting information. Sorry? Yes.
I'm George Zogel. I'm a first-year law student here at Case, and I'm interested in knowing your view on aggression in terms of crimes in Article 5 of the Rome Statute, and where you think those developments might go if there are any.
I will disappoint you because I will give no answer. No, I am the prosecutor. You discuss the law with the states, and I will apply the law. Okay. You have some question here.
In the last few years, we've seen Augusto Pinochet being arrested in Britain from a warrant issued by a Spanish judge. And we saw, I think it was Berezovsky that was arrested, I think, in Switzerland, and a warrant that was issued from Russia. And there are a number of countries, especially in Europe, that have laws that authorize them to act extra-jurisdictionally. I'm just wondering, what is the mechanism for enforcing your arrest warrant? I mean, is Interpol obligated to enforce it, or the police in any particular country that is a signatory to the treaty obligated to enforce it?
No, okay. First, we are not a universal jurisdiction court. We are a treaty court. So basically, the states have criminal jurisdictions on crimes committed in their own territory or by their own nationals. This is our jurisdiction, because what the state did is give us jurisdictions in their own jurisdiction. So I am not applying universal jurisdictions. It's just a jurisdiction based on the national jurisdiction who provide to us jurisdiction. Who will execute it? Yes. If as soon Haroum travel outside the Sudan, he will be arrested. It's an Interpol red notice. If he remains inside Sudan, is the government of the Sudan responsible. They have to do it. That's why what we need is that the Security Council has to present to them clearly You have the legal mandate. You have to do it. More questions here?
One last question.
Yes. I will do my question to myself. Yeah, because I came here to work, and I need academic communities working on this. So, can you discuss how we can focus in the issues I presented? How we can describe this different legal system? Normally, the legal system is based in a territory. Historically, it was a king. Here it was a republic, but historically it was a king in other countries who controlled a territory with an army, and the people had to pay taxes, and to reduce problems, they established the law, and then were judges, more and more independent, and at the end were prosecutors. We start a system on the contrary, with no land, no king, no army, just the law, judges and prosecutors. And then this required a different approach. And my feeling is legal scholars are still talking about 18th century, 19th century. Today it's different. You are crossing the wall with internet, with different ways, and then we need institutions to deal with this problem. And the question for me is, can you do it? Can you do it? Because they will need it. So my question is to you. I believe this new idea requires analysis. We need help in terms of new solutions, and also negotiators in the UN, Security Council. Imagine, Security Council, there are discussions on Security Council. But in the real life, this treaty changed the dynamic of the Security Council without changing the rules of the Security Council. Normally now, in the last 2 years, I saw there was almost 9 or 10 state parties inside the Security Council. So they had a commitment to justice, and that's why Darfur case came. France and UK were leading. So my feeling is things are happening, and we are still reading books from the past. And then we need an update. I need you understanding and discussing this new legal system, because I need help. Thank you so much for your attention.
There are refreshments upstairs, and you'll have a chance to ask questions one-on-one. And before you all leave, I have a question for you. Does anybody know why there's a photo of Nicole Kidman behind us? Does anybody know that? Yes. The Interpreter. This was the first movie ever to portray the International Criminal Court in a positive light. At the end of that movie, people were clapping when the warlord was sent to the ICC, and I think the fact that American and international popular culture is behind you is a good sign. So thank you. We'll see you upstairs.